mute the whole time. Okay, we're bringing in the jury. We have been having some discussions about jury instructions, and Mr. Ewan wants to examine the deputy sheriff regarding his police report, which I'm told him he can do when the officer is on the stand. Also, we discussed that Ms. Ewan is not required to be back here unless the court notifies her of such fact. Come on in. Please take your seats. Good morning. So the jury is walking back in the courtroom. Please be seated, everyone. I'll just remind the parties in the jury that we are recording these proceedings and we're streaming them on YouTube, which is what we've done for the last year and a half for all court hearings, so that public can access the hearings without being present in court. I believe yesterday the parties examined Miss Ewan, and then at about 4:45 we elected, I guess I determined that that was all we were going to hear yesterday, so we're ready if the city has any additional witnesses to call this morning.
Yes, Your Honor. The city calls the Deputy Chad Arthur Miller, Kitsap County Sheriff's Office. I will go retrieve him.
Thank you. No. Come forward, please, sir. Have you raise your right hand. You swear or affirm your testimony today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Please come forward. Officer, I am giving the witnesses the choice whether they want to wear their masks or not. You're not required to wear the mask. And I'll turn the case over to Mr. Hersey. Go ahead.
Good morning. Good morning. Please tell members of the jury your name.
My name is Chad Miller.
And where are you from?
I work for Kitsap County Sheriff's Office.
And did you grow up in the area?
Marysville, close enough.
All right. How long have you worked for the Sheriff's Office?
I've been employed at Kitsap County for about 23 years. I have a total of about 26 years of total of law enforcement.
And where did you work prior to that?
Okanagan County in Eastern Washington.
And you were a sheriff there, or
Correct.
a deputy sheriff there?
Yes.
Okay. Could you briefly describe the nature of your educational background and training for this position?
I'm an associate's degree in criminal justice from Everett Community College. I attended the Washington State Basic Law Enforcement Academy. That's 1995. And throughout the course of the last 26 years, I've had several different in-service classes, criminal investigation, phony accident investigations, vessel operations, criminal investigations is kind of a whole ongoing gamut of related topics.
Okay. And in the course of your many years, have you ever responded to calls involving allegations of domestic violence?
Yes.
If you could put a number on it, about how many calls do you think you get on average in a given week or so?
On domestics, I mean, the last couple of years have been a lot of like behavioral health calls, but which are mostly domestics. I would say probably anywhere from 10 to 20 domestics a week.
And just briefly describe what your job responsibilities are as a deputy with the Sheriff's Office here.
Basically, I respond to 911 calls for service. You call 911, whatever your allegations or your statements are. We go to investigate or they go to the scene or talk to somebody on the phone and determine if a crime has occurred and go and take action from there.
Were you working on April 15th, 2021?
Yes, I was.
And let me back up a little bit. How many locations does Kitsap County Sheriff's Office have within the county?
We have 3 offices. Our main hub office is in Port Orchard, and then we have a patrol office in Silverdale, and then a satellite office in Kingston that's not manned by office staff, but it's the deputies come and go.
Okay. And do you work in any of those locations primarily, or do you
The
find
last
yourself everywhere?
15 years, I primarily work Central Kitsap, so I primarily work out of the Silverdale Patrol Office.
So does that mean you're generally patrolling Central Kitsap as opposed to north or south?
Yeah, Central Kitsap from basically Sherman Hill north to Bremerton south to Illhead to the canal.
And going back to April 15th, 2021, on that day, did you have occasion to respond to a call in your office parking lot at around 10:20 p.m.?
Yes,
And can you tell me a little bit about the nature of that 911 call?
I think it was more about 7:30 p.m.
Oh, 7:30, excuse me.
Yeah.
So could you tell me a little bit about the nature of that call?
A caller from Washington, D.C. called about, I believe, her sister-in-law, Shaya, was out in the parking lot and she was talking to her on the phone. Shaya had made some comments about she was in a really bad relationship in her marriage and she didn't feel safe and she wanted to basically try to leave the marriage and be safe.
And did you get a description of what this vehicle would look like in the parking lot?
Yeah, oh, sorry, a white van.
Okay. And did you go out in the parking lot?
Yes.
And what did you see when you were out there?
There was a female sitting in the driver's seat. She had I want to say she had a small child in her lap, I think maybe 9 or 10 month old. And she was on the phone and she was crying and very upset. Just cried for probably about 4 or 5 minutes till she settled down and opened the door to talk to me.
Was anyone else in the vehicle?
There was a male sitting in the passenger seat, but I don't recall his name.
Okay. So when she was crying, did she open the door and talk to you, or did it take her a while to even compose
It took
the
her a
door?
few minutes before she got off the phone and kind of composed herself, and she opened the door. That's when I spoke with her.
Okay. And when she did open the door, tell the jury everything you noticed about her demeanor and her appearance.
She was, I mean, she looked like she'd been crying for a while. She was pretty upset. I mean, I don't remember what her clothes were. If she was pretty disheveled, I mean, she just had average, like a shirt and maybe pants on. But emotionally wise, she was very upset.
Okay. And what happened next?
I asked her what was going on, what can we do to help you out? And she had said that she was in a bad relationship with her husband, Daniel, and that she wanted to get out of the relationship and the marriage, and she had turned her location services off on her phone, so she'd come to the sheriff's office to talk to us. Apparently, she gets in trouble from Daniel if she turns her location services off. But it sounds like her sister-in-law and her brother in Washington, D.C. finally convinced her to come to the sheriff's office or the police for help.
Did she mention anything to you about prior threats that her husband made against her?
If I remember right, they weren't married very long. I want to say they got married in, I think it was mid-2020. And she had mentioned that early on in the marriage, he had told her that if she leaves him for another man, that he would kill her.
And did she disclose to you at that point anything physical that had recently happened between them?
It was within the last few days. She had FaceTimed a male friend of hers in Germany that she knew. And apparently she didn't clear it with Daniel, and he found out about it later. And they got in an argument, and during the course of the argument, Daniel pushed her, and she landed into the counter of the kitchen or somewhere in the house, and she had a bruise on her lower back from the dispute.
Okay. Did she show you or let you observe this alleged bruise?
I don't have a note in our report, but I believe she did show me the bruise, but I didn't document the time.
Okay. But did you see a bruise?
I believe so.
Okay. And what did you do next?
Kind of talked to her for a little while, saying, hey, we have some resources here in Kitsap County. We have the YWCA shelter, which helps women and abusive relationships and children. They have services and assistance and so forth. So I tried to talk to her about going there. She didn't really want to go there. I provided her a domestic violence resource handout, which has a number for the YWCA. I kept trying to encourage her to go to the YWCA because in the last 26 years of doing this job, you see I've dealt with a lot of victims, and it's just a repeated cycle. They're scared. They don't know what to do. And you try to give them some guidance to go because they end up circling around and going right back into where they're trying to get out of. So she told me she didn't want to go to the YWCA. She was going to go to a friend's house in Port Orchard. And then I left her with the resource handout and told her if she had any questions to give me a call, see what we do to help you out. And then that's the last I saw of her.
Okay. And did you do anything with respect to the criminal investigation involving that incident you did before with the pushing into the counter?
It occurred in the city of Bremerton, and it wasn't an imminent 4-hour occurrence for domestic violence mandatory arrest. So what I did, I completed the report. It had to be forwarded to Bremerton PD for possible follow-up.
Okay. And you say it occurred in the city of Bremerton. How do you know that?
She told me where her home address was.
Okay. Nothing further.
Mr. Yulin, do you have any questions of Officer Miller?
Miller.
Yes, all right, thank you.
No worries.
Morning, Mr. Miller.
Morning.
Ms. All, thank you for being here.
Oh, you're welcome.
I guess the first question I would ask is, would it be fair to say that you're very busy?
It depends on day to day, but we're usually pretty constant, yes.
10 to 20 domestics a week, correct?
Correct. That's just a rough guess. I mean, some weeks are busier than others. We work a 55-hour work week.
Sounds like you guys are very busy. When you interviewed Mrs. Yulin, did you take notes?
I did not.
You did not. So this is all I wrote.
Correct.
Okay. So stated here, which you didn't touch on, I noticed that you touched on most of the things in this area. That she has 2 small boys from a previous relationship.
You need to speak up a little bit so the jury can hear you.
Oh, okay, I apologize.
Thank you.
You stated in your narrative that she had 2 small boys from a previous relationship. Is that true?
Correct.
That was from memory.
Correct.
Would it surprise you to know that she has 2 small girls from a previous relationship?
No, I thought she told me boys, but like I said, I talked to her at 7:30 and wrote the report at 8:20.
You also reported that she was holding a 10-month-old child. Would it shock you to know that child she was holding was born on 2/1/21?
No, it's a small child. Like I said, my kids are older and couldn't give an accurate month age of that size.
Well, that would put her age at approximately 2.5 months.
Okay.
That's an 8-month discrepancy.
Okay.
No further questions, John?
Anything else, Mr. Hersey?
Briefly, redirect. One question I had to ask you. Do you recall if Ms. Yulin mentioned anything about a firearm having it in her possession?
She did. She had it in her diaper bag or a bag in the van.
Nothing further.
Anything else, Mr. Yulin? Thank you, Officer Miller. Please don't discuss your testimony with anyone else until the case is over, and you're free to go. Thanks for being here.
Thank you, sir.
City have any additional witnesses?
Yes, Officer Brandon Greenhill.
Please come forward, sir. Have you raise your right hand. You swear or affirm your testimony today will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Please have a seat.
Thank
You're welcome to remove your mask if you would like to do so. And Mr. Hersey will have some questions for you, and Mr. Hewlin might have some questions for you. Go ahead, Mr. Hersey.
Good morning.
Morning.
Could you please state your name for the members of the jury?
It's Brandon Greenhill.
And where are you from?
I am from Bremerton. Lived here since '96.
And how old were you then?
Oh, man, I think I was 12.
Okay. And what do you do for a living now?
I'm a police officer for the city of Bremerton
How long have you worked for the city of Bremerton?
since 2008.
And what did you do prior to joining the police department?
I was in the United States Marine Corps right out of high school in 2003 until 2007.
And what did you do after the Marine Corps?
I applied for numerous police agencies and I was hired by the city of Tacoma, where I stayed there for about a year in 2007.
Could you briefly describe to the members of the jury a bit about your training?
I've been to the CJTC, the State Academy, 720 hours of state training. Once out of the academy, you go on to your FTO phase. And I did my FTO phase with the city of Tacoma. Then once out of Tacoma, then I did it again for the city of Bremerton as it was required by the state. And then throughout my career, I've had numerous trainings. I was in our special operations group, so I've been to narcotics investigation schools. I've been to several other trainings that pertain to the job, such as the first aid instructor, in the SWAT school. There's a lot of schools, but usually it just entails to my job, and those are pretty much my specialized trainings.
You mentioned something about FTO training. Could you
That's
explain what that is?
Field training. So when you come out of the academy, city of Bremerton was 3 months. So you spend 3 months with a different officer that's trained. Actually, sorry, I forgot to mention that, I am an FTO as well. So I actually train new officers as they come out of the academy or if they lateral from another agency. Generally, they'll spend a month with each officer.
And I think you mentioned different divisions within the Bremerton Police Department. What are you assigned to right now?
I'm in the patrol division.
What does the patrol division do?
We are the ones that when you call 911, we get all the calls and we respond. We do traffic enforcement as a collateral duty. We also have a traffic division, but we do a proactive patrol. So see a speeding car, we'll stop the speeding car, just stuff like that.
And you worked in other prior divisions. Which ones were those?
I was in a special operations group, which handled our narcotics investigations. So just anything that came up narcotic wise, vice, which is prostitution, stuff like that.
Okay, and I'd like to direct your attention to April 16th, 2021. Were you working that day?
I was.
And that day, did you have occasion to receive a report from the Kitsap County Sheriff's Office?
I did. I was assigned that case as follow-up since the crime occurred in the city of Bremerton.
Okay. And what did that referral involve? Which parties?
What do you mean?
Who was there a suspect and an alleged victim
Yeah.
at that point?
So the victim was Shea Yulin, and it was regarding her and her husband, Daniel Yulin.
And you see the defendant in the courtroom
Yes.
today, Mr. Daniel Ewing.
Yes, he's off to my right.
You just described what he's wearing.
A gray shirt, a striped tie, and a white mask.
Let the record reflect, the witness has identified the defendant. So, do you recall which deputy referred the case to you?
It was Deputy Miller.
And
I received the report and it indicated alleged assault from Shea.
and what did you do once you received that report?
So after I read the report, there was concerns about going to her house, so I attempted to call her based off the numbers we had. It didn't work. I left a voicemail for a number that I thought was correct, and I couldn't get an answer.
Did you give up at that point?
No, I looked at history and I noticed her sister-in-law, Nicole, had called, and so I called her to try to get in contact with Shea, and that's how it all started.
Okay. What happened after you called Nicole?
Nicole explained to me how pretty much what happened with the accounting report, and I asked her what she knew, and she explained that she was in an unstable relationship with her husband.
Okay. And after talking to Nicole, what did you do next?
I asked if she would be willing to get me in touch with Shea, because I did drive by the residence at 1770 Rasmussen and noticed her white minivan was in the driveway. And since she didn't want contact at her residence, I asked that Nicole get in contact with Shea for me and see if she was willing to speak with me.
And did you park right in front of the residence?
No, I didn't. I was actually around the corner in a big church parking lot, just out of the way.
Did you eventually receive a call from Shea?
I was told that I can call her, but that if Daniel was not home, if that he did return home, she'd have to hang up immediately because she didn't want him to know that she was talking to the police. So I called her.
Okay. And could you tell the jury everything you remember from that phone call?
So when I called Nicole, I'm sorry, Shea, and she can explain that if Daniel was to return home, that I'd hang up, and I told her that I understood. And she said that she didn't deserve this, meaning that she didn't deserve to go through what was happening in our marriage. That I explained to her I received a report from the Kitsap County Sheriff's Office and asked her regarding that. And she did disclose that she was shoved against the counter because she was standing in Daniel's way. And in that process, it caused a very large bruise on her side, and it did cause pain. She also told me that she's in a very controlling relationship. Her phone gets tracked and her location is always known by Daniel because he's afraid that she's going to cheat on her, and that pretty much she can't go anywhere without him knowing.
Now, do you recall anything about her demeanor on that phone call?
She was very, very upset. During like the first words of our conversation, she said she didn't deserve this. And I said, you're right. And I say this to most domestic violence victims, that they don't deserve to be in an abusive relationship. And then she just broke down crying again. And she was very adamant that she didn't deserve this. And she was almost sobbing to the point where I couldn't talk to her. I had to let her calm down. And I think I felt there was some relief that she was able to do that. So.
At any point during the conversation, did she disclose any prior threats?
When I asked her if Daniel made any threats, she mentioned that he would threaten to kill her and her ex-husband if he ever found out that they were talking. And there was a comment about an ex of Daniel's named Tiffany, and asked, you remember what I did to Tiffany, and referenced how she slammed her face into the ground.
Now, you said she mentioned being shoved into the counter and leaving a bruise. At any point did she indicate she took photographs of that bruise or anything like that?
Yes, she did. She had it photographed on her phone, and she sent it via text message to my department cell phone.
And Officer Greenhill, I'm going to show you what has already been admitted into evidence. City's identification exhibit number 1 and 2. You recognize?
This is the photographs I received.
Okay. And do these appear to be fair and accurate?
Yes, they do.
Okay. And let me ask you, in your training experience, have you ever examined bruises?
I have several.
And from your life experience, have you been able to examine bruises that are maybe 1 day old, 2 days old, a week old?
If you qualify to identify bruising.
He's asking him that. So we're going to find out if he's qualified. Go ahead, you can continue.
So in your training experience and life experience, have you ever, when investigating cases of assault or cases of violence, examined bruises on alleged victims?
Yes.
Okay. And in the course of your investigation, have you been able, or course of your training experience, have you been able to distinguish between fresh bruises versus older bruises?
Yes.
And in your training experience, is a bruise of this nature consistent with a bruise from an incident about 2 days prior?
Yes. Very correct.
And the direction of the bruise, is that consistent with what she described being shoved into a counter?
Yes, it's a very long line that's very symmetrical to a countertop.
Now, at this point, did you ask her about cooperating with a potential criminal case?
I did, and there was clearly hesitation because she was afraid of what would happen, especially if Daniel found out that, for one, if she was even talking to the police, but if she moved forward with a criminal trial.
And just to be clear, did she tell you explicitly that she was afraid of what would happen?
Yes.
So at that point, what did you do next?
I tried to make her aware that we're here to help her. That's generally how we do things for domestic violence victims, because there's a repeated pattern, and I wanted to make sure she knew she had help. I explained to her the resources that she can get. I explained she can get no contact orders. I explained that 911 was always here for her. I explained to her she had my cell phone if I was working. If she needed to call me, she was able to do that.
And you gave her your cell phone number?
I did, yes.
At any point in the future, did you ever hear from Mrs. Yulin again?
I did on the 27th when I was working at about 9:30 in the morning. I received a phone call.
And tell me about that phone call.
She was at work. She was crying again, saying she can't do this. Explained how Daniel found out that she spoke to the police and that she wanted to get a no contact order.
Did she say whether the defendant was home at the time?
He was not. He was at work.
And you mentioned that she was interested in getting a no contact order. Did you provide that information about how to do that?
I did, and she seemed like she really wanted to get it done. So I even called our court, this court, and asked what the fastest way was. And I was told because they lived together that she would have to go to Port Orford Superior Court to get it. And so I relayed that information to her, and she went there and obtained one.
And did you hear back from Ms. Yulin later that day?
Yes, a few hours later, she called me back saying that the order was granted by a Superior Court judge and that she wanted assistance going to her home to get her belongings just for her safety in case Daniel returned.
Did she provide you with a copy of that no contact order?
I did get a copy. Right.
I could just have this marked. If you don't mind. I believe this would be number 8. Thank you. Officer Green, I'm handing you what has been marked as exhibit number 8 for the city. Will you take a look at that document and review it? Let me know when you're done taking a look at it.
Yes. Okay.
Do you recognize that?
I do, yes.
What is it?
It's a temporary order for protection, and Shaya being the protected person and Daniel being the respondent.
Well, let me back up. After she got back from the courthouse, did you go over to her house on 17?
I did, I
17
met
Rouse?
her at her residence. Yes.
At that point, did she give you a copy of that no contact order?
Yes, she showed me a copy. It was entered into WASIC NCIC, which is our database where these are entered. So we can see them if we run names. But it was entered, it was valid, but it had not been served because she is updated.
And does that appear to be a fair and accurate copy of the no contact order she showed you on April 27, 2021?
Yes, it does.
I'll move to admit city identification number 8.
Let's see, please. Mr. Yulin, have you seen this?
Yes, Your Honor.
Any objection if the court enters it into evidence?
No, Your Honor.
All right, so.
Hold on,
Oh, sorry.
I still get to say yes or no. Exhibit 8 is admitted. Thank you.
Thank you, Your Honor, I apologize.
No problem.
Can you tell me what happened next when you were at the house at 717 Rasmussen Lane?
So she began to pack her belongings because she intended to leave the area for her safety, based off of the order and what's transpired with reporting her stuff for information to the police. She did tell me about damage to a door, how she had to lock herself inside her daughter's bedroom because she confronted Daniel about some allegations about Daniel wanting to, I believe, sleep with a friend 2 weeks before the wedding. That upset him, so she had to lock herself in the bedroom door, inside the bedroom, and shut the door and locked it. During that time, Daniel made a comment to her about the effect of, "You think this door is going to keep me out?" And she ended up I didn't see the door, but she sent me photographs of the door through my phone again. And the door was destroyed. It had a large, probably basketball-sized hole on the outside of it. So from the hallway going into the bedroom, and then the other side of the door was completely destroyed, facing outwards. And so you can tell that there was some effort to get through the door.
And back up. So this was on April 27th. Did she indicate at that time what day this incident with the door happened?
I would have to look at the date. I believe it was the Sunday before, but I want to see.
Okay. And you said that she texted you photos of the door itself.
Yes.
I'm going to direct your attention to exhibit number 4 and number 3. You recognize the photos I've handed to you.
Yep, these are the photos she texted.
And they appear to be fair and accurate. Same photos you received.
Yes.
All right. All right. So what happened next?
Essentially, she collected her belongings. I explained to her once she left, I would attempt to make phone contact with Daniel for the order service and see if he wanted to provide a statement.
And did she provide a statement?
Daniel?
Oh, excuse me. No, I'm sorry. Mrs. Yulin, did she provide a sworn statement at that time?
She did. I provided it to her. I believe it was over email because she returned back to work. This was after she came to order, and that she agreed that she wanted to move forward with prosecution. And so I explained to her that we have a domestic violence supplemental form which contains a handwritten statement, which was voluntarily, and that if she chose to write it, she could. And she agreed to write it on her own. She made her own statements on it. She completed it. And then I received it back and I submitted it along with my report.
Okay. And after receiving that statement, did she indicate what her plan was next?
She was going to leave the area, and she told me it was going to, I believe it was, I want to say, but she said it was an undisclosed location for her safety. But she was going to leave the residence and go from there.
Nothing further this time, right?
Mr. Yulin, any questions of Officer Greeno?
Yes, Your Honor. morning.
Morning.
Thank you for being here. Are you fairly busy in your duties as a Bremerton police officer?
What's that?
Are you fairly busy in your duties as a Bremerton police officer?
Most days, yes.
On your notes on 4/16 was you had said that you asked about the assault involving the bruised or bruised back. She had said they were talking on Monday in the kitchen. And she was in the way, so Daniel shoved her into the counter. Is that what you reported?
Seems accurate, yes.
Is that what she told you?
Yes.
So on 4/27, on the next follow-up, when this affidavit was written,
Mhm.
which you attested to, reviewed, it talks about the assault occurring in the bathroom. You didn't think about the discrepancies in the statement?
It's her statement.
Right, that's her statement there, but you didn't think to ask her about her previous statement in the kitchen that you just said that she said?
Well, it's her statement. I'm not gonna make her change her statement.
But you didn't ask her why she changed her statement.
Well, for one, it's very small and you have to read it. And two, I'm not gonna make her change her statement. If that's a statement that she was gonna provide, then that was a statement I was gonna submit.
So, in your course as a Bremerton police officer, if you were interviewing a suspect, and the suspect made an inaccurate statement, would that cause you to further question that subject on setting an inaccurate statement?
Provided to me, like orally,
Yes.
probably. But again, this was her statement, which she provided voluntarily and on her own. And I wasn't gonna question the statement that she provided to me voluntarily and on her own.
Fair enough. So, when you relate this information to Mr. Hersey, which I imagine that's how the chain of evidence went, right?
Well, I complete my report and then I submit it to the prosecutor's office.
And then did you ever speak with Mr. Hersey and follow up with Mr. Hersey about obtaining warrants or anything like that? You guys speak on the phone?
We did, yes.
So you guys came together and made decisions regarding this case, correct?
We made a decision, yes.
But you guys didn't ever ask yourselves at any time why there was a discrepancy.
Well,
Or did you guys even notice that there was a discrepancy?
Well, at that point, during our phone conversation, no, we didn't even have it at that point. It was a decision whether or not she was safe or not, making an arrest at that time. That's what that phone conversation was about.
So let me ask you this. You weren't privy to Mr. Hersey's opening statement. Mr. Hersey's opening statement attested that the assault occurred in the kitchen. And I imagine he did that based on your supplement report. So was it Mr. Hersey's fault or was it your fault?
Objection, argumentative.
What do you mean by fault?
Well, I just want to know, all the way through this whole process, they've had this information and they can't even get it right. So
But
why?
what's your question? What do you mean, whose fault was it?
I'm just trying to figure out why there was no questions asked. Why nobody asked why there was discrepancies in statements and now we're switching on. So, I can't. I really think that-
I'll sustain the objection. Go ahead, move on.
In the course of your duties as a Bremerton police officer, have you ever encountered an alleged victim that lied?
Yes.
No further questions.
Mr. Hersey?
So, Mr. Yulin just asked you if we ever communicated about this case during your investigation. Do you recall the nature of our conversation?
The phone conversation we had that day? I do, yes.
Did we discuss the kitchen or the bedroom at all?
No.
What did we?
Objection. Hearsay.
You opened the door, Your Honor.
Ish. Ish.
Hang on a second. The question is, did they discuss whether it was the kitchen or the bedroom? That's not,
From your response for speculation, we can't cross-examine Mr. Hersey. It's the same guy down on Monday. Should be the same exact guy down on Monday.
that's not, I'm gonna overrule the objection. You can answer whether or not you discussed that. The yes or no question, it's not a statement being offered, it's a yes or no question. Right?
Right.
Did you understand the question?
Yes, Your Honor.
Do you have an answer?
We did not discuss those things on the phone that day.
Now, is Mr. and Mrs. Yulin's kitchen in the city of Bremerton?
Yes, it is.
Is there a bathroom in the city of Bremerton?
Yes, it is.
Is that bruising consistent with being pushed into a counter that could either exist in a kitchen or a bathroom?
Yes, possibly.
If someone submits a sworn affidavit under penalty of perjury, is it your general practice to confront them and ask if they change anything in their sworn statement?
No.
Why not?
Because it's their statement, it's their words, that's the statement that they provide, and that's the statement we'll submit.
And just to be clear, do you recall the day that you received Mrs. Yulin's statement?
I believe it was the 27th, the same day she got the order.
And you recall the date that we had a conversation about this case? Was it before or after?
It was before.
Before.
Mr. Ewan,
No questions, John.
may Officer Greenhill be excused?
Absolutely.
Yes.
Thank you, sir.
Thank you, Your Honor.
You're free to go. Thanks for being here. Sorry you had to come in 2 days. I'll take the blame for that.
It's okay.
Please don't discuss your testimony with anyone else until the case is over. Mr. Hersey, does the city have other witnesses?
No, the city rests.
It's now 10:20. Mr. Yulin, are you ready to make an opening statement?
Your Honor, I would just actually move to go to closing arguments. I'm not going to follow that last witness that I had scheduled.
Okay, so you rest as well.
I rest as well.
Very good. Okay, ladies and gentlemen, what the lawyers and I, or the parties and I need to do now is talk about the jury instructions that are going to be presented to you. That means you are going to go back to the deliberation room. You don't get to start deliberating, but that's just what we call it, the jury room. Please don't start discussing the case yet. You can talk about football, baseball, weather, smoke, pandemic, whatever you want. We're going to take a few minutes to review these, and then we're going to have you back in here. You'll get copies of the instructions. I will read the instructions to you, and then we're going to have closing arguments from the parties. So if you'll go with Becky. Oh, you didn't meet Becky. This is Becky. Becky, my new bailiff for today. Do you mind closing that door in case, usually they take the jury down to the bathroom? Or Becky can, one of you guys. Thank you, Rebecca. You let them go in by themselves?
I have observed that this is the restroom.
Right.
Do you need me in here or can I bring them down?
I always need you, but I don't need you in here right now. Go ahead. Thank you. Okay, so you said, do you have a copy of this?
I have an email. I have an email, yeah.
Is that how you want to, do you want a hard, paper copy?
Oh, I don't necessarily need one if we're just gonna go over.
Sure, we're just gonna go over
Yeah,
them.
I'm okay.
Okay,
I'll just pull them up right now.
Okay. and most of the, just to let you know, Mr. Yulin, generally speaking, most of these, most instructions are found in a book. They're called Washington Pattern Instruction, I'm not sure what the C stands for. But
Criminal?
are they WIPICs? I think they're
WIPIC?
civil WIPICs too, though.
There are. I have no idea why they're called there, but.
So anyway, these are pretty standard instructions for criminal cases, and typically courts are supposed to follow the WIPIC instructions. I think I'll be able to access them if we need to. So the first one is the proposed instructions, WIPIC 102. It's basically an introductory instruction telling the jury what their responsibilities are. Do you have any objection if I give WIPIC number 102? So that'll be number 1. The second proposed instruction is also directed at the jury, WIPIC 104. Do you have any objection if the court gives WIPIC 104? That would be number 2. Number 3 is basically to protect you. It's that you're presumed innocent, that they have to prove the case beyond a reasonable doubt. That's WIPIC 401. Any objection if I give WIPIC 401? Number 4, make sure that they understand, or the proposed, sorry, it's WIPIC 301, which would be number 4 if I give it, separates the 2 counts so that jurors don't assume that if you're guilty of one, you're guilty of the other.
Right.
So any objection if I give that?
No.
So that's 4. Then there's a definition of circumstantial versus direct evidence. Any objection if I give that?
No.
That's 5. Then to protect you again, the next is that you're not required to testify, and the fact that you did not testify cannot be used to infer guilt or prejudice you in any way. Any objection to that?
Yeah, no objection. No. I think we skipped one. No.
I think our order might be different, Judge.
What one did I miss?
I'm not sure you missed anything. For
I mean,
example,
I knew where you were at. I found where you're at, but there was one past where I was. There's a.
Which one do you think what does it say?
The evidence has been presented to you may either be direct or circumstantial. Which one direct evidence refers to evidence?
Yeah, no, that's the one we just did, 5.
Okay.
So the next one is that you're not required to testify. You have any objection if I give that?
No.
So that'll be 6. 7, or proposed 7, I guess it would be, you may give such weight and credibility to any alleged out-of-court statement of the defendant as you see fit, taking into consideration the surrounding circumstances. Any objection if I give that? And this is, I'm gonna have to draft a couple limiting instructions. One of them is gonna pertain to what they can consider. And I guess we need to know, we might wanna put it here. Go ahead, Mr.
Yeah.
Mueller.
Yeah. I mean, because there was a lot of witness testimony that yeah, I don't have a problem with that one, I guess. I mean, what was this one?
No objection? So that'll be number 7. Now, you didn't even introduce the criminal one, right?
no. So this was the issue I was thinking of. The city did not introduce any evidence of prior convictions for the defendant. The defendant actually did on his own cross-examination of Mrs. Yulin. No, and like this instruction I don't think applies because this instruction specifically is for with respect to impeachment convictions if the defendant testifies. So I think this should be removed. I don't know if there's an applicable instruction under these circumstances where a defendant introduces his own criminal history for a different purpose.
I'm trying to find. If it's here. So the city's withdrawing the request to put in WIPIC 506.
Yes.
And then the next one is the definition of
505.
assault.
505?
Yeah, 505.
505, yeah.
The next one is the definition. Wait. That's, WIPIC says a person commits the crime of assault in the fourth degree when he or she commits an assault.
This is hands down the most useless jury instruction of all time. I've said this many times. I think they still advise you to include this as the definition for assault in the fourth degree. 3525. Let me see. I feel bad even asking for it, but that's what they recommend. Actually, there is a note that says this instruction is typically used only when fourth degree assault is submitted to the jury as a lesser included offense.
So you can just get rid of that whole thing.
I'd be happy to get rid of this. It's not very helpful. I'll defer to the court and Mr. Hewlett if you would like it.
I don't know if it's very helpful to me either.
It's a little circuitous.
Sorry, I'm just looking, I'm trying to get, I'm not familiar with this. The icons on this computer. And I'm looking for my inside course and I'm not. I think I need to just go into Google.
Are you looking for the jury instruction page on 3525?
Well, I can't even find my jury instructions, so I have to go in.
I can, if you'd like, I can read the note on use section for this 3525.
Yeah, I don't think we need 3525. So I'll note that as withdrawn. Then, the definition of an assault is 3550. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not really sensitive. That seems to be the definition of assault. Mr. Yulin, any objection if I give 3550?
No.
So that is going to be number 8. The definition of intent is WIPIC 1001. Any objection if I give that?
No.
That'll be number 9. Bodily injury. Well, why do we need bodily injury?
You know, I don't know if we do, to be honest with you. The assault definition references physical injury. It says regardless of whether any physical injury is done to a person. And then the note for WIPIC 2.03 says use this definition when an instruction refers to bodily injury, physical injury, or bodily harm. That being said, because it doesn't matter, physical injury is done and you have committed an assault, I don't think it's entirely necessary. I included it in an abundance of caution.
But it's not, bodily injury is not used in the instruction.
No, but the note on bodily injury says use this definition when an instruction refers to bodily injury, physical injury, or bodily harm, and the definition of assault references physical injury.
Right. So why don't they have a definition of physical injury?
I don't know. And, you know, I'm fine removing this. I was putting it here in abundance of caution.
Mr. Yulin, in or out?
We can get rid of it.
Okay, we'll take it out because bodily injury isn't used, the words are not used. So the next is the to convict instruction. To convict the defendant of the crime of assault in the 4th degree, each of the following elements must be proved beyond a reasonable doubt. April 12th, that you assaulted Shayla Ulan, and they occurred in the city of Bremerton. That seems to be the instruction that I'm required to give. Any objection to that, Mr. Ulan?
No.
So 10 will be in. That'll be 10. Then malicious mischief is the next one, 8510. Any objection if we give that as number 11?
No.
And then the definition of knowing or knowingly, any objection? Yeah, because the definition of malicious mischief is knowingly and maliciously. So there's also going to be a definition for malicious. So that's why we need it. That'll be number 12. Then the definition for malice and malicious is 13. The to convict will be 14. Then the definition of intimate partner, which the city also has to prove. Any objection if that's 14, Mr. Ewan?
No.
And 15 is the final instruction. So I've numbered these, but I'm going to renumber them once we talk about the limiting instruction. So help me out with that, Mr. Hersey. How many limiting instructions do you think we need? I think we need one regarding 404B.
I agree.
And the part that I've drafted, or so far the part that I've drafted is evidence has been admitted on the subject of defendant's prior acts of violence against, well, we can just say prior acts of violence for the limited purpose of assessing the victim's state of mind. What do you think the limiting instruction should say?
I think it should say alleged victim for one. Be safe. I don't want to create an implication
Sure.
that you're commenting on.
Yeah, no, that's a good idea. I got that from Cook.
Was that straight out of? Well, Cook. The issue was it was insufficient, right? Was that,
Well, because it said credibility, but then that was overruled by majors, and they said it was okay to talk about credibility.
okay.
But I didn't want to violate Cook. But what do you think this goes to really the purpose of admitting that evidence, which the court agreed to do to show her state of mind?
I think that is sufficient, along with an admonishment that it shall not be considered. It is not admissible and shall not be considered to show that the defendant had a propensity to commit acts of violence against the victim and should not be considered for that purpose. And I think, I guess the purpose is the credibility of the victim and to rebut recantation or minimization. I don't know if it needs to be that detailed though as to the purpose.
Was there something else? Was there any other evidence that warrants limiting instruction?
So essentially the 404B evidence was the prior act of violence and then the prior threats. I don't know if it makes sense to include both in the same limiting instruction or to do two separate ones.
Well, isn't a threat an act of violence?
That I don't know. And that's why I would want to be a little more descriptive for the jury so there's no argument on appeal that they were instructed to not consider the prior alleged shoving when she was pregnant, but not judge propensity based on the threats.
Yeah, how about this? Evidence has been admitted on the subject of defendant's prior threats and acts of violence for the limited purpose of assessing the alleged victim's state of mind. This evidence cannot be considered by you to show any propensity of the defendant to commit violence.
I'm good with that.
All right, so we're gonna need that to be made into an instruction. Who's gonna do that? Can you do it?
I can, if you can maybe email me the language, I can pop it into the right format.
Okay, I modified it a little bit. So here's what it's gonna say. Evidence has been admitted on the subject of the defendant's prior threats and acts of violence for the limited purpose of allowing the jury to assess the alleged victim's state of mind. This evidence may not be considered by you to show any propensity of the defendant to commit acts of violence or for any other purpose. Good?
No objection.
Okay, and then I think it should be, it's just, we don't need a title or anything. That's just gonna be an instruction. And I think I'll take your input on when it should, what number it should have. We do have that number 7 that says you may give such weight and credibility to any alleged out-of-court statement of the defendant as you see fit. We could have it right before that or right after that.
I defer to the court and Mr. Yu on that.
One more time, Your Honor.
So I'm trying to figure out where to put this instruction in the scheme of all of them. And there is number 7, which says you may give such weight and credibility to any alleged out-of-court statements of the defendant as you see fit, taking into consideration the surrounding circumstances. And then I would propose that we put this in right after that.
That sounds great.
Okay, so this will be number 8. I'm sending it to you now. I'll just call it instruction. And if you could put, and the reason I'm having him do it is then it'll look exactly like the rest of these.
Okay.
So for the record, Mr. Ewan, do you have any specific instructions that you would like to introduce?
No.
And do you have any other objections to the ones that that I'm planning on introducing.
I do not.
So when you get that one, you're gonna give it to me. And then I'm gonna number all these again and have Dawn or someone who Dawn bosses around, make copies of these for council. And also 6 copies, 1 for me and 6 copies for the jury. You want to take a break, Mr. Yulin? You can. It's going to take about 10 minutes to get this put together, so let's reconvene at 11.
Sounds good, thanks.
All right, thank you. Oh, yeah, you may go off the record. Why didn't I think of that? Then, what? Who? What?
Still on YouTube.
So? Oh, so be
I would
careful.
like you to be aware of that.
Oh, you mean I should mute myself before I make any comments about life in general? I apparently have not been on Zoom, but I don't really care. It's really about the jury here and the instructions. So for the record, I'm reading an instruction for anybody who's looking on YouTube. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. So just to clarify for the audience, if there is an audience, I just read instruction WIPIC number 1.02 to the jury, which is always read in any criminal matter. And I apologize that it wasn't all recorded for you. Okay, instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3, the defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The city is a plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or the lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or the lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, then you're satisfied beyond a reasonable doubt. Instruction number 4. A separate crime is charged in each count. You must decide each count separately. Your verdict on one count should not control your verdict on the other count. Instruction number 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in the case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in the case. One is not necessarily more or less valuable than the other. Instruction number 6. The defendant is not required to testify. You may not use the fact the defendant has not testified to infer guilt or to prejudice him in any way. Instruction number 7. You may give such weight and credibility to any alleged out-of-court statements of the defendant as you see fit, taking into consideration the surrounding circumstances. Instruction number 8. Evidence has been admitted on the subject of the defendant's prior threats and acts of violence for the limited purpose of allowing the jury to assess the alleged victim's state of mind. This evidence may not be considered by you to show any propensity of the defendant to commit acts of violence or for any other purpose. Instruction number 9. An assault is an intentional touching or striking of another person that is harmful or offensive regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 11. To convict the defendant of the crime of assault in the 4th degree, each of the following elements of the crime must be proved beyond a reasonable doubt. Number 1, that on or about April 12, 2021, the defendant assaulted Shea Ulin. And 2, that this act occurred in the city of Bremerton. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 12. A person commits the crime of malicious mischief in the 3rd degree when he or she knowingly and maliciously causes physical damage to the property of another. Instruction number 13. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 14. Malice and maliciously mean an evil intent, wish, or design to vex, annoy, or injure another person. Malice may be, but is not required to be, inferred from an act done in willful disregard for the rights of another. Instruction number 15. To convict the defendant of the crime of malicious mischief in the 3rd degree, each of the following 2 elements must be proved beyond a reasonable doubt. 1, that on or about April 25th, 2021, the defendant knowingly and maliciously caused physical damage to the property of another, and 2, that the acts occurred in the city of Bremerton, or the act. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 16. Intimate partner means spouses or domestic partners or former domestic partners, persons who have a child in common, regardless of whether they have been married or have lived together at any time, or adult persons presently or previously residing together who have or have had a dating relationship. Dating relationship means a social relationship of a romantic nature. In deciding whether 2 people had a dating relationship, you may consider all relevant factors, including the nature of any relationship between them, the length of time that any relationship existed, and the frequency of any interaction between them. Instruction number 17. This is the last instruction I will be reading to you. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in the case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you've taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. So that form is actually the next page, which is called Question from Deliberating Jury. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff, and then I will confer with the parties to determine what response, if any, can be given to the question. You will be given the exhibits admitted into evidence, these instructions, and some verdict forms for recording your verdict. There were no exhibits that were not admitted, so that next line doesn't really apply. I don't remember, so maybe I better read it. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will go to the jury room with you. You must fill in the blank provided in each verdict form, the words "not guilty" or the word "guilty" according to the decision that you reach. You will also be given a special verdict form for the crimes of assault in the 4th degree and malicious mischief in the 3rd degree. If you find the defendant not guilty of these crimes, do not use the special verdict form. If you find the defendant guilty of these crimes, you will then use the special verdict form and fill in the blank with the answer yes or no according to the decision that you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict forms to express your decision. The presiding juror must sign the verdict forms and notify the bailiff, and the bailiff will bring you into court to declare your verdict. So, ladies and gentlemen, at this time, please give your full attention to the closing argument of Mr. Hersey on behalf of the city. Mr. Hersey.
Thank you, Judge. Good morning, everyone. I want to thank you again for your time and your attention throughout the course of this trial. I said at the beginning, jury duty for most people isn't anyone's idea of a good time. You've been paying attention, you've been on time, you've sacrificed a lot to be here. Some of you have to work, some of you had to set an alarm for the first time after being retired to get here. Some of you wanted to be here, but a lot of you had to wear very silly looking masks. And all along the way, you paid attention and you've been here, and I really appreciate it. What you participate in today ensures that everyone has a fair trial. I don't want to belabor the point, but what this case really comes down to, what this case is all about, is power, control, jealousy, and fear. Mrs. Yulin said many times throughout her testimony, people tell stories that tend to favor them. She said this in response to a few questions. They tend to tell stories that favor them. And that's exactly what we saw during her testimony. The facts showed she testified to favor Mr. Yulin and more importantly, favor herself to protect herself. Because of the evidence you've heard, she had very, very good reason to testify the way she did. She testified completely inconsistently with what she told her family members, what she told Officer Greenhill on multiple occasions, what she told Deputy Miller, what she told the court in the sworn affidavits, what she wrote in the sworn affidavits to the Bremerton Police Department. She had very good reason to testify the way she did yesterday. Now remember, members of the jury, in the court's instruction number 1, the judge told you, you are the sole judges of the credibility of the witnesses who testified. I want you to think about, remember back to Mrs. Yulin's testimony, the way she testified. I want you to remember the way that she testified when I was asking the questions versus the way she testified when Mr. Yulin was asking her questions. The demeanor is like a coin flip. Stood up to me, but once he started asking her questions, she became very, very timid. That is indicative of the relationship that she had with Mr. Yulin, one of power, control, jealousy, and fear. And imagine how hard that must have been for Mrs. Yulin to not only he has to testify against him, but to answer questions from him directly. Have to talk about what happened in front of a room full of strangers. Now, I'll go over what we've heard in the evidence. You heard from Mrs. Yulin, you heard about her background, her family, all being in Idaho, no one in the area. 30 years old. She's got 2 children from a prior relationship, which she shares custody with the father of the child, 50-50. Remember, he's local in Bremerton. Her daughters, Olivia and Adeline, are here. She works. She doesn't work that often, about 20 and 24 hours a week, I think she said at the hospital. And she had been on maternity leave, and she went back on that first day on April 27th. So her and the defendant, they really relied on each other. The way she testified about him, she really loved him. She wanted to be back with him. Now, she told you, what the evidence you heard on April 15th, she called her brother, who lived on the East Coast, and then her sister-in-law, Nicole Reiner, called 911. You heard evidence that she turned off her location services on her phone for the purpose of the defendant to now track her to see that she was driving to the Kitsap County Sheriff's Office. She had to pack up her 3-month-old child, had to get in the car, while on the phone with her sister-in-law, drive up and do what was probably a really hard thing for her to do. Get to that point where you have the bravery enough to finally leave this relationship. Finally seek help after talking to your brother, after talking to family members, try and getting to that point where you say, I need help out of this relationship. But again, you heard from Deputy Miller today, even when he got there. It took a few minutes for her to even open the door. She was crying, she was so upset. And when he tried to talk her into it, tried to say, hey, we have these resources, the YWCA can help you with this. No. And you heard from Mrs. Yulin, she went back to the house that night. Now you heard several times what happened on that incident on 4/12. She was FaceTiming with a friend in Germany. She received follow-up texts that the defendant saw. That's where the jealousy comes in. That's where the cheating accusations come in. They have an argument, grabs her by the arms, shoves her into the counter, leaving a large bruise. Now, when Officer Greenhill gets a case, he calls, no answer, calls the sister-in-law, tells him to call back. Hoping that he changed his ways, she was already back at the house. She told Officer Greenhill she'd have to hang up if he came home. She didn't want to be in any trouble. Her testimony that she lost her privileges, to know where he was. She sent Officer Greenhill photos of her back, but refused to cooperate any further. Again, Officer Greenhill, just like Deputy Miller, told her, Here are these resources, we're here to help. She wasn't ready to cooperate at that point. It wasn't until April 27th when things got really bad. She called up Officer Greenhill crying at 9:30 in the morning on her own, voluntarily. Said, I'm ready. I'm ready to get a no contact order. I'm ready to get out of this relationship. I'm ready to cooperate. She goes to the courthouse on her own, fills out another sworn statement. Penalty of perjury describing everything that's happened in the relationship up to that point. These incidents of violence on 412, 425, the prior threats, prior violence, where he shoved her onto the bed when she was pregnant. And she asked the court for a no contact order longer than 1 year. She said, I need this. And at that point, she finally had the bravery to get herself, get out and go to Idaho, get away from him and have some separation. And she disclosed at that point to Officer Greenhill what happened just a couple of days prior. She found out about the infidelity, started an argument. He got angry. She felt she needed to flee to her infant daughter's room, lock the door behind her, and hold on to her 11-week daughter while he's pounding on the door saying, you think this door is going to stop me? Keep in mind, she had to hide the gun in her infant daughter's room. She told you that he didn't know the password to the safe. But in her sworn affidavit, which you'll get to read, she said he knows the password. He's taken the gun before. She had every reason to fear Mr. Yolen. And she finally got to that point where she was ready for help. And she went to Idaho, stayed there for a little bit. Of course, after a little while, she found her way back to Mr. Yolen. Found her way back. The desire to make peace took over. She still had her children, her 2 daughters from the other relationship. They're still here in Bremerton. Father's still here. Her life is still here. Her job is still here. Keep in mind that when she actually found the courage to go to the courthouse and found the courage to report what's been going on, that was the first day she was back at work after maternity. She was willing to leave that behind because that's her state of mind at that moment, saying it's better just to get out of here. Now, remember, you are the sole judge of credibility, and you've seen quite a bit of inconsistent testimony from this. I'd like to go over some of that. You'll have all these documents, photographs, back in the jury room with you, and I encourage you to read it. And like she said, her initial affidavit was written very, very small, tiny print. If you can read it, you just might have to squint a little bit. On her direct testimony, she told you all that he never grabbed her, he never shoved her, he never threatened her on April 12th. Yet, in her own statement, I want to make sure I get the words right. He got up. I tried to hug him again, calm him down so he would listen. And he grabbed my arms and shoved me backwards into the counter and told me he didn't want me touching him at all. Now, Mrs. Yolen, when you get back there, you'll notice she testified pretty consistently with her entire statement until it started to implicate him. Suddenly, she had very selective memory of what happened and what she remembered and what she may have just made up. So take a look at this, because everything else was pretty consistent about everything that led up to this incident. She was consistent with until it gets to the point where he assaults her. And at that point, no, he never grabbed me. He never shoved me. It was simply, I was kind of in the way, and it was an accident. And you saw the bruise. If this was just someone walking past somebody, it's a pretty big bruise on her back. And also, you'll notice she told you he never grabbed her by the arms. Yet when she filled out this statement, take a look at the diagram of victim injuries. She circles on her left bicep, her right forearm, where there were bruises immediately afterwards, where he grabbed her. Now, moving on to April 16th, again, she said there was no assault on 4/12. That's obviously not what you heard from Officer Greenhill and then Deputy Miller. The photos taken her back are entirely consistent with her initial statements. She didn't even seem to dispute that he broke down the door, except this time she said that she wasn't watching, so she wasn't sure what happened. And you'll see in her petition to the court, I found out yesterday, 4/26, and she got that date wrong, that he tried to sleep with someone 2 weeks before our wedding. I locked myself in our daughter's room. He proceeded to break the door down to get in. She also told you that on 4/12, he never made any threats to her. But you'll see again in this statement and both in the petition, she says very clearly that he would fuck her up like he did to Tiffany. He doesn't leave her alone. And when asked whether he threatened her, she just said no. That seems like a pretty specific threat to just make up and then forget. She also testified entirely inconsistently about their relationship. She said in her petition, she says he does. All of her statements she made to law enforcement, he tracks her location using Find My Friend and similar apps. She said that, well, I offer this unilaterally. I want him to know where I am. Obviously, that's not what she said to the officers or in her statements. She said he never isolates her, never controls her. In her petition, she said that's exactly what he does. That he never threatens her. Ever. You'll see in the petition, it's not the case. Aside from threatening to fuck her up like he did to Tiffany, threatening to kill her if you and your ex, if he ever found out that her and her ex were sleeping together, and this was just 2 days after their wedding. This is in the petition itself. Also in her petition, she said, I'm afraid of what he might do. He's told me stories of how he told his baby's mom he would kill her and took her into the woods to scare her. I don't know what he's willing to do to get back at me with this. Members of the jury, there are reasons for the way she testified this way. Love, children, she still has a child in common with this man. She still has children keeping her in Bremerton. She can't just pack up and leave. Finances, only working 24 hours a week, relying on him, splitting costs, owning a home together. Sometimes it's just easier to put this stuff behind you. Sometimes it's just easier to make peace. But the primary reason is fear. I don't know what he's willing to do to get back at me for this. Would you expect her to testify consistently? Would you expect her to protect herself? Members of the jury, facts in this case are clear. The evidence is overwhelming. I ask that you return verdicts of guilty.
Thank you, Mr. Hersey. Ladies and gentlemen, at this time, please give your full attention to the closing arguments of Mr. Hewlin.
It's been a long road. I said that when I first got in front of you guys. And the lady said, I don't like you already. First, I'm going to start out with the jury instruction number 14. I'm going to start with malice. Mean and evil intent, wish or design to vex, annoy, or injure another person. In reference to that case, no, We are not denying the fact that I punched through that door. I punched through that door. Absolutely punched through that door. But it was not with an evil intent. or with-
Objection, defendant's testifying.
Or do I refer myself as the defendant, or what should I refer myself, because he's made a lot of conjecture about what happened that night.
I'm going to overrule the objection. You can continue.
Thank you. That's what you have to find when you're making finding malicious. Was there ill intent? And the alleged victim in this case said here in open court that when I entered that room, I apologized for her having to find out that way. I apologized for her even having to find out. And then I exited the room and exited the house. The prosecutor spoke about consistency, inconsistency, the jumble of when she lied, when she didn't lie, did she lie? Did she lie? That's a prosecutor's sole witness to these crimes that happened or allegedly happened. And he's calling her testimony into question. And yet, using testimony from earlier and saying that's bad. I mean, if we can decipher this web of information and truth and untruth, you got me, because I'm still guessing on a lot of it. And that's reasonable doubt. I'm asking you guys today to find me not guilty on reasons that may not necessarily fit the statute or fit what you exact design of the law was. I'm asking you to find me guilty, not guilty in that gray area. That gray area of, was a man trying to remove himself from the situation so it wouldn't get worse? That gray area of, was a man seeking to harm the person he loves most? Throughout this process, it's been about a 4-month process. I haven't been able to see my wife, not once. The law states I can't see her because we have a pre-trial no contact order. He's right. It's a hardship on our family, a hardship that we have endured. A hardship.
Objection, now the defendant is testifying, facts not in evidence.
Sustained. You can argue what the facts show, not anything new. Go ahead. Directed the jury
The
disregard.
prosecutor has argued that there's reasons behind the change in testimony. Only reasoning ourselves well. Thank you, I rest.
Thank you, Mr. Yulin. Ladies and gentlemen, do you have any additional?
Briefly.
We'll have you give your full attention to Mr. Hersey on behalf of the city.
Mr. Yulin referenced jury instruction number 14. I'd like you to take a look at that one. So malice and maliciously means an evil intent, wish, or design to vex, annoy, or injure another person. Malice may be, but is not required to be, inferred from an act done in willful disregard of the rights of another. Take a look at that door. Take a look at the hole in that door. The amount of force that would be required to open it and bust through that. You can infer based on the size of that door, the hole in that door, that his intent was to annoy, vex, injure another person, right? So she locked the door. She said, I don't want to talk to you, and he busted down. If there was actually any concern for safety, something of that nature, could have called 911, could have done any number of things short of busting that door. Mr. Yulin also spoke of the reason she would testify inconsistently, and the only one he said he believed there was love. He's right. That is a good reason for her to testify inconsistently. She told you straight up, she told you directly, she wants this case gone. She wants no contact order gone. If she wants that, isn't she going to testify in a way that is going to accomplish that goal? To testify to protect him so he is not convicted. Members of the jury, you are the sole judges of credibility. Based on everything you've seen, everything you've heard, those photographs, those statements, I urge you to consider it in its totality, bring your common sense to the jury room and reviewing. Thank you.
Thank you, Mr. Hersey.
Mayor's comment, you know.
No, you don't get, only the city gets the rebuttal because the city has the burden of proof. Ladies and gentlemen, that concludes the closing arguments, and really now the trial is turned over to you. I want to make sure that we have all the exhibits that were admitted into evidence. These will go with you to the jury deliberation room. Was there did you introduce the Smith affidavit?
Yes, that's in there.
I don't see it here. You see, you can find it.
Oh, did I accidentally take it during one? Maybe. Yeah, this petition in this matter right here. 1 and 3.
Okay, so my clerk will bring all these exhibits to the deliberation room with you, and you can start deliberating. I need to consult with my court manager about whether the courthouse is going to be open or not between 12 and 1, because usually it's closed. It should be open, even though the jury's just deliberating. So we may be checking in with you in a few minutes about that, but you can take them back and we'll stay on the record. So can you close the door, please? Well, I wanted to talk to you before this, but now we'll talk. We're still on the record and the parties are in here. I guess we have a couple options. We can let the jury deliberate and keep the courthouse open. Or if you want to close the courthouse, we probably need to have them go get lunch. And I don't know. What do you want to do?
Well, I would need to check with the security officer to see if he's available to keep it open, because Ian's not here today, so I don't have any backup on that. If we stay open, that means he's not gonna get a lunch break at all today. And I can check with him to see if he's good to do that. Let me ask that question first.
Well, yeah, or, maybe till 12:30. If they don't come back by 12:30, we might have to send them out, or we could bring them back and have them eat lunch and not deliberate. I think it's okay if they're not deliberating that the courthouse not be open. So yeah, why don't you see if he can stay till 12, see if he's willing to stay with the door open. Where does he eat lunch?
I don't know, he usually leaves the building.
Is there a reason we have to have security from 12 to 1?
If people are coming into the building, that's when he needs to be screened.
Why?
For safety reasons. I can get my lunch and watch the front door too if you want me to, that's fine.
Well, see what he's doing, see if he can stay to 12:30, and then we might have someone there from 12:30 to 1. I can even do it.
Since I can't call you back, Mayor, I'm just gonna set the phone down while I go ask him, I'll be right back.
Okay. And where are you gonna be for like the next hour?
I'll just hang out in my office right here.
Where will you
I
be?
believe we have 10 minutes away. My house is 8 minutes away or so too.
Can I get your phone number?
360-979-6820.
Okay. Well, I know you're good to go as long as you'll answer your phone and I can call you and let you know when you need to come back.
Yeah, okay. You're on.
Okay,
Thanks, man.
sure, thank you.
Picture on it.
No worries. I guess you can go too.
Yeah, I'll just hang out there probably until
12:30 and I'll check in before I go anywhere.
Okay. Thank you.
Yep.
We're going off the record.
You still in there, Judge?
Yeah,
He said he's able to stay.
okay. We'll check in with you about that at around 12:30.
Okay.
Okay, thank you.